Having regard to the historic power stakes involved in this election appeal and stay proceeding, vigorous arguments, marked by strokes of heat and flashes of light, have been heard in this application for stay, and the time consumed at the bar has been considerably more than when like matters have been routinely dealt with by this court. Let it be plainly understood that the court decides forensic questions without getting embroiled in non-legal disputes, working as it does in a soundproof system of sorts. Moreover, notwithstanding the unusual, though natural, excitement and importance surrounding the case, the court is the quiet of the storm center and views, with an equal eye, the claims on each side, taking judicial note of the high issues and balance of convenience in the wider context. Arguments about public sentiment, political propriety and moral compulsion, though touched upon at the bar and relevant at other levels, fall beyond the conventional judicial orbit and have to be discriminately shifted. Nevertheless, counsel has pressed before me the propriety and urgency of the court taking into consideration the national situation even while exercising its discretionary power. As a counterweight to this submission, the opposite counsel has claimed that no republic can surrender its democratic destiny to a single soul without being guilty of overpowering the parliamentary process by a personality cult. This brings to the fore an activist interrogation about the cognoscibility of such considerations by a court. Do the judicial process and its traditional methodology sometimes make the judicature look obsolete, with eyes open on law and closed on society, forgetting the integral yoga of law and society? If national crisis and democratic considerations, and not mere balance of convenience and interests of justice, were to be major inputs in the judge's exercise of discretion, systemic changes and shifts in judicial attitudes may perhaps be needed. Sitting in time-honored forensic surroundings, I am constrained to judge the issues before me by the canons sanctified by the usage of this court. Now to the points urged before me, more or less by way of preliminary objection, counsel asserted that the petitioner, having come with unclean hands, was not entitled to seek the equitable relief of stay. Because, the argument runs, her advocate induced the High Court into granting a stay by misrepresenting that if the judgment came into immediate effect, the national government would be paralyzed for want of a prime minister, and so time was needed for the ruling party to elect a new leader to head the government. Taken in by this alleged critical need of the democratic process, the learned judge granted 20 days stay. This spell was perverted to consolidate her leadership, not to find a successor. If this version of the respondent were veracious, the petitioner's conduct were dubious, and this court would not condone such solemn mockery. According to the latter, all in a hurry a stay was moved by the Allahabad advocate praying for stay, stating both the need to elect a leader and to enable filing of an appeal. The Congress Parliamentary Party was since convoked, but there was a unanimous vote, faith in the petitioner as leader and Prime Minister. She could only call a meeting of the party, but not coerce the members to elect anyone other than the one they had set their hearts upon. Don't forget to like, share and subscribe to Lakshya Steno. Stay connected with us on social media. For any query, WhatsApp on 9991560799, link in description.